finally, good evening, everybody, and welcome and thank you for joining us and for giving us your time away from your family to come and listen to what Bruce and Bruno have to share with us. I know Bruno from a property network group that I go to from time to time, and he often speaks at this event. And I've gotten to know Bruno over the years, and over the last few years, we've been chatting about Airbnb and specifically body corporates and the legal aspects around short-term rentals. So we've had some very interesting conversations. And Bruno is also part of the Property Law Alliance. If you want to go and check out their Facebook group, they have a weekly session. Bruno, just refresh my memory, is it on a Wednesday?
Yeah, Wednesday evening at 6 o'clock, live on Facebook from 6 to about 6:30.
Okay, and that's when you are taking all questions property related and you discuss it on that forum. And thank you for that recording that you sent to me of the recent one that you had, where you went into a whole discussion about short-term rental and how short is short, because that's my big question always. And it was a very interesting discussion. I have posted that on some of the groups as well. And I'll also share it to my YouTube channel for those who want to go and watch it later. The Facebook group for the Property Law Alliance and for Bruno. Bruce, would you mind sharing that in the chat box with everybody, and then they can go and like your page? So I don't want to steal any of your thunder, Bruno, but if you can maybe just introduce yourself and Bruce and give us a little bit of background to tell us what you specialize in and what made you so interested in this topic around Airbnb and body corporates.
Sure. Thanks so much, Karen. I really appreciate you having me on. And yeah, over the years, my conversations with you have actually been very insightful. So believe it or not, like even from a legal perspective, us as attorneys, we need that engagement, we need that interaction, because it's normally the questions that the clients pose that actually make us start thinking and give us the need to go out, research more, and start getting into that speciality. So, thank you so much for that. And I mean, you had a very big part to play in this whole body corporate versus Airbnb conundrum, where other people I've also engaged after the fact have, it's been a stimulating conversation. So I'll let Bruce introduce himself as soon as I introduce myself. But just to give the viewers like a bit of context on who I am. I've been practicing as an attorney now for, I think it's going around 15, 16 years. I've always been so my background is in litigation. So that in essence means that I've always been involved in the problem solving side of things. It's always looking at specific issues, everything scrambled up, and then trying to piece it together and come up with a solution that works. My specialization, albeit in litigation, has also led me to get the job done, not necessarily using court. And that is quite important, especially when it comes to the property industry, because this isn't like medical negligence or RAF claims, for example, where pretty much the only way you can get it done is by going to court. And it's the same routine day in and day out. In our interactions with sheriffs or body corporates, every body corporate, every managing agent, every estate agent, every tenant, everyone, it's a different interaction. So it's also quite dynamic. So your approach is a lot broader, and there's a lot more that you need to think about. The reason why I got into property was obviously because of how it's such a good investment asset. So in my mind, when I looked at a field to work within, where our article, they were already very deep into property. And as opposed to trying to move on to something else, I actually realized the benefit behind this, the opportunities, and like in fairness, also looking for those clients, those dynamic clients with wealth, and looking for those dynamic clients with great ideas and great business strategies. And property was just one of the indicators that kind of brought that challenge onto me. That then over the years, it's been specializing in property investments, sale and executions, evictions, the like, and eventually got to, with the Airbnb is just one facet of it. Body corporate issues is just one facet of it. And bringing them together was actually two worlds almost colliding, because I've always helped body corporates trying to establish best practice for their sectional schemes. And now with my Airbnb clients, it's trying to protect them in their investment, and these just two worlds colliding. It is just one of those things that needs some form of resolution. One way or another, we need to get to the bottom of it, because there's no way that these can be sustainable the way that they're going at the moment. So that's just a little bit about me and how I work. So Bruce.
Well, obviously I'm Bruce Barkhuizen, attorney and notary. Been practicing for a number of years now. Initially, I started out in property, corporate law, commercial law, and I've always been interested in the commercial aspect of property and how the big names have always made lots of money, and the property is always featured in their road to success, the road to wealth. For instance, when you think of Robert Kiyosaki, Rich Dad Poor Dad in America, it's been a big part of his progression to being very wealthy and having a sustainable growth of his wealth. And hence I decided to come to learn more about in the property spectrum and how it's generated, how it's preserved, and more importantly, how it is actually created. And the legal questions around property are just absolutely interesting and astounding at times. For instance, they talk about the landlords, tacit hypothet, and those sort of things are very interesting to me. And in particular, sectional title schemes. It's such a unique creation that it's very hard to compare to other jurisdictions. So I've found it very interesting. Also from the rules perspective, the powers perspective, and because it's such a gray area, it's actually quite an interesting area to work in trying to resolve disputes, because there is no real position in most cases. You obviously have to go with what's practical, what makes sense, what's fair, what's reasonable. And that's often the departure that almost everybody takes across the spectrum. When you think of the likes of your ombud at CSOS, they also use that as guiding principles towards making decisions, and the courts also tend to use similar criterion.
Okay.
So that's where I come from.
Okay, great. And Bruno, I'm so glad that you mentioned the situation where you are saying, you always try to find a solution outside of court, because I think I shared with you the story of me purchasing a property in a sectional title development and got resistance from the body corporate. And I made sure that before I purchased the property, I read the conduct rules and that there was nothing that prevented short-term rentals. And then they resisted me doing Airbnb, and I immediately contacted, sometimes I can be a little bit too feisty. And I immediately contacted a friend of mine who is actually specializing in conveyancing. But I said to him, Johan, just please send these people a letter, take them out by the knees and tell them it ain't gonna happen. And he convinced me exactly what you have just said. And he said, you know what? Every single time that I have sat around a table, every single time in my life that I've sat around a table, we have managed to accomplish more than if you just go the legal route and you go to court. And that's exactly what we did. We sat around a table. I asked them what their concerns were. They told me what their concerns were, and we talked through it, and we came up with a solution. And it's now 3 years later, and I am still happily Airbnb-ing in that particular complex. And it's all just because people were willing to sit around a table and thrash it out. But let's get this party started, and let's get some questions from the floor. I know that you guys are dying to ask questions. If you have already sent a question, just put up your hand and I'm going to unmute you, and then you can ask your question for Bruce or Bruno. So you can just do a virtual hand raise. You'll see at the bottom of your screen, there are reactions, a reactions button. And if you click on that, there's a button to raise your hand. So don't be shy, go and raise your hand and ask whatever question it is that you want to ask. We're sitting on a healthy component here of 27 people. Who is going to be the first to raise a hand? Let's see. Is there nobody? If there's nobody, then Bruno, I think we should just then tackle some of the questions that I have forwarded to you guys, or some of the scenarios, if you want to pull that up, and we can start chatting about that. And then as questions come along, you guys can just do a virtual hand raise, leave it there, and when Bruno is done, then we'll give you a turn to ask your question.
No worries. Do you have the questions there with you? Do you want me to pull them up?
I don't have them handy, but I can open them quickly.
I do have
you
it
got
open.
them? Okay, excellent.
Yeah, I do. So the first batch of questions that you sent me, the first 10. So maybe let's just start from the top and move our way down. So concern from body corporate regarding strangers in and out of the complex and possible security breaches after handing out remotes to them. All right. I don't know if you want to add anything to the question, Karen.
No, that's fine. You could just continue.
And so we're actually going to see that a lot of these questions can get grouped together. So as we go through the list, some of them are actually going to be answered. The one very common theme that I found throughout most of the disputes regarding tenancy within body corporates. Now, maybe before we start answering this specific question in the detail, or rather addressing the comment, I think it is vital to remember that, you know, as Airbnb hosts, you guys have a platform that you feel is very well very well regulated. The way that things are, you know, the way that the rules are set, the way that the payment plans, the rating system, everything is done in such a way that it just feels well within control. If anything does go wrong, there's reporting mechanisms, and the way that the credit card data is captured, there's always almost recourse you feel within the Airbnb environment. Now, we need to take a step back away from that comfort zone, because what we do need to remember is, if we're going to be impartial and apply the rules across the board, it's not Airbnb, it's short-term rentals. So you're looking at, for example, at what your typical rentals are. So you've got your long-term. And now, as I explained yesterday in the Property Law Alliance, how a lot of people, especially laypersons, see the term long-term leasing versus how lawyers see it. Long-term leasing for lawyers is 10 years plus. This is a contract that gets registered at the deeds office, and that gives a tenant a real security, so a real right over the property by virtue of his tenancy. But because it's registered, he's protected across, like from everyone else around him. Now, when people typically ask me, and now property investors, when they say long-term leases, they're actually relatively comparing it to a short-term lease. So this typically means that your normal lease, one sees it lasts for about 1 year. So it's a 6-month to a 12-month lease. So short-term leases would be anything that, you know, you don't consider to be usual or long-term. So anything under 6 months. Now, nothing in our law specifically states what the length of a lease is going to be or should be. So there's no strict definition where you cut down the middle and go, anything underneath this is short-term, anything above this is long-term. It doesn't exist at all. So now we're throwing around these terms very loosely, where we're not correctly defining long-term, we're not correctly defining short-term. Each of us has our own perception of it. So if you look at Cape Town Municipality, for example, they're comfortable with the 31-day mark for short-term Airbnb rentals. If you look at Rental Housing Tribunal, the 1 month also seems to be you know, a fair way to look at it. Other people, on the other hand, go, well, typically a lease is 12 months. So 6 months, anything less than 6 months seems to be what they'd consider to be short term. And unfortunately, this is the topic of debate. Now, how this ties in is the fact that we in the property community haven't had enough exposure to this to be able to experience cases, case law, rules, regulations being promulgated that deal with this more specifically. So at this moment in time, we're in an environment that's so dynamic and so fresh with ideas that we've got a lot of opportunities to make things happen. But in the same breath, we're also in a very uncertain environment. There's a lot of gray areas. The attorney down the corridor from me could have a very different idea than I do on how to approach certain issues. But it does give an opportunity. It does give a level of opportunity, but in the same breath, it does create a bit of risk. So like with Karen's scenario, for instance, of buying a unit in a sectional scheme, reading the rules, being very comfortable that everything looks okay, and then next thing you know, a rule gets promulgated saying you're not allowed to do it. That's the type of issues that we're experiencing now because there is no set answer for it. And one of the most common reasons for that is security. Now, take Airbnb out the picture, short-term rentals. I'll give you an example, for instance. I mean, what if someone was renting out a house per hour, right? That's not something that anyone's interested in. So for a second, put yourself in the position of the body corporate. Put yourself wherever you guys live. Imagine that in that complex, you're having to deal with short-term rentals outside of the Airbnb space that allow people to come in whenever they want. They don't have any set rules. People come in for a night just to party it up and they leave immediately. There's a complete disregard for the rules. And that's the kind of mindset I think we as Airbnb hosts need to enter this. Because if we enter it with the right mindset, we understand the pains that we need to fix. And going back to what you'd said about sitting around a table trying to resolve this as opposed to litigating is exactly why we do that. We work in the gray area because only in the gray area are you able to find solutions that suit both parties. And you can only do that if you actually step into their shoes for a second and you understand what their pains are. Otherwise, it's going to be a yes versus no answer. Security is one of those things. You're worried about letting people onto premises that you don't know. What if they come in to stake out units? They want to steal cars, or they're opportunistic. I mean, I'm sorry, but we do live in South Africa. We've got a high crime rate. This is a reality that we need to consider. So you'll see through the questions, the issue of security comes up, but it is just important from the outset to approach it from that impartial perspective of, is it fair to be worried about security? And as we'll touch on later, one of the things that we start working towards is, well, what can we offer then in order to provide this level of security? How are you guys different? What rules are you willing to adhere to in order to make this work? But we'll obviously get to that a little bit later. Bruce, I don't know if there's anything you want to add to that, to the security component?
Well, you're absolutely right that if you can address the pain, you actually go a long way to, one, helping the body corporate to help you, and also, coincidentally, if you're able to resolve the issue regarding security, you might also help eliminate the reason why they're pushing for a particular rule. For instance, they say they want to ban short-term rentals purely because of the security concerns. So if you're able to resolve that, then, and then they do subsequently pass a rule, then when you challenge it, for instance, at CSOS, then you've got good grounds for it to be ruled as unreasonable and unfair because the security aspect was already dealt with and properly attended to. And hence the rule is actually unreasonable and there's no point in it, in essence, actually, other than to target and discriminate a particular sector of the economy.
I like that argument, and it is not impossible to overcome that resistance around towards short-term rentals when it comes to security, because that is the exact same problem that the complex had that I told you the story about just now, where we sat around the table. When I said to them, you know what, I've purchased this property, I'm going to be here for a very long time, and so are you, so why don't we just discuss what we can do, what your concerns are. And I said, so what are your concerns? And the main thing they said was security. So once I have satisfied them that security is less of a risk in my case than what it is with other tenants in the complex, then they were happy. So it is quite possible to overcome that security argument. So I think that's a good starting point, Bruno. Shall we go to the next question? And I see Tanya and Nolene have raised their hands here. And we can go through the questions that people are asking now and see if there's anything left on the list that I sent you once we've gone through everybody's questions here. So let's first go to Tanya. Tanya, I'm going to ask you to unmute yourself and then you can ask your question.
Okay, can you hear me? It's actually Gert, Tanya's husband.
Oh, hello, Gert, Tanya's husband. We can't see you, but we can hear you.
Yeah, look, I think the issue is around security. So our situation, we actually had a body corporate meeting last Thursday in which 9 of the 10 people said, yeah, you're okay to do it. But then somebody said, what about the security concerns? Which I think is absolutely valid. So I suppose, and probably not for this, because I'm not sure if there's a legal opinion, but we need to figure out what we can do to address their security concerns. So,
okay.
Yeah, and maybe we can take that offline at a later stage because it's much more of a practical question, and I suppose it is about a legal question. Yeah.
Gert, well, sorry, Gert, I can't. Please forgive me because I can't see your face. So, and I normally go on faces and not by names. Have you done my workshop?
Yes, we have.
Okay, excellent. So. Yeah. In my workshop, I normally say to people, you know, put yourself in your neighbor's shoes. If you were living in the unit next door and you saw new faces every week or every month coming in and out, you would also be concerned and wondering what is going on. So it is always my number one recommendation to go to your neighbors and establish some kind of friendship or a relationship with them so that you tell them what it is that you are doing and you satisfy them in terms of all the checks that you are doing to make sure that you are not letting people into the complex that are going to pose a security risk, and that you also share your mobile number with them because they are your eyes and ears on the ground if you are not going to be there, so that they are the first to phone you to say, hey, there's some noise happening next door. They phone you first before they phone the body corporate, and then you can react immediately. I think there needs to be such a strong drive amongst hosts to be responsible hosts. And Bruno, I think that is what you were alluding to earlier, is you need to be a responsible host and put yourself in the shoes of the other people in the complex. And that already goes a long way. And when you share with your body corporate the checks that you are doing on people before you allow them to book, and all the verifications and so forth, and the reviews that you read and the questions that you ask and the information that you obtain from them before you allow them to check into your unit, you know, those checks are a heck of a lot more than what many long-term, and now I'm using the term that Bruno doesn't like, but in our mind, long-term, normal, you know, let's talk about a traditional rental where you sign a 1-year lease with a tenant. We are already, if you've done my workshop and you are doing what I am sharing in that workshop and what I'm showing you, then you are already doing so much more than what a normal landlord would do for a long-term tenant. A traditional tenant, sorry.
Yeah, fair enough. No, I get you. I think from this point on, when we say long-term, we mean traditional.
We understand. So, we mean traditional. Yeah. Okay. Yeah. So, Gert, does that answer your question a little bit better? Does it give you a bit more comfort?
Yes.
Okay, excellent. Great. Then let's go to Nolene. Nolene, would you unmute yourself? I've just given you the tick there.
Hello, Karen.
Hi, Nolene.
Hi. Okay. I do now real short term.
Okay.
Weekend, week,
okay.
holiday accommodation.
At a time, right.
2 days at a time or whatever. And I've got more than one Airbnb in one complex, like a holiday resort type or something, but the houses all belong to private owners and I rent it out on their behalf. Now, I just want to know from Bruno if he can perhaps help me on the COVID rules in an instant like this. For instance, I've got, say, for instance, one family that rents 2 houses for a weekend. and we work under a homeowners association. So according to them, the families that's in 2 different houses is not allowed to visit each other during that weekend in this area.
Do you mean in terms of COVID concerns?
Yes, yes. According to them, with COVID, rules says they're not allowed to mix over the weekend. The one house, for instance, they're not allowed to go and visit the other house and then all be together in one house.
All right, let's hear what.
Tell me, Nolene,
Mm-hmm.
is that where's this rule exactly? Is this a HOA rule or
No,
a
apparently,
rule?
according to them, it's a COVID rule.
Oh, not that I've heard of.
No.
No.
I think maybe during the early levels of lockdown, you know, we weren't allowed to have social gatherings, and maybe during those levels that could hold water. But right now, during level 1, Bruce, I'm not aware of any such regulation. So maybe they are still living in the old lockdown level.
Yeah,
Absolutely.
yeah. And also, if a house can accommodate 8 guests, and they won't want them to get like 2 visitors for the afternoon.
So there's a lot to be said about things that are voluntary and situations that are now forced on people. So I can understand internal rules at a backpackers where there's dorm rooms and it's an open dorm room, there's 6 people staying in there, and now you've got beds that are very close to each other. And there I would say that, you know what, social distancing, you're probably going to need to reduce the capacity of that room based on size, etc., etc. But I mean, I'm sorry, if you want to invite people over to your house, you're more than welcome to. And if you're renting a house and you invite people over, the only thing that can stop you, in my opinion, would be if it's house rules or a specific term in the, call it tenancy agreement or service agreement, that restricts having other people in the house. But that's a very private relationship or private right, not something that applies across South Africa at all. Yeah.
Thank you very much. No,
sorry, if you don't mind me just chiming in here, you mentioned that these properties are owned, but you are letting them out for the owners, correct?
Correct, yes.
Yes. Well, in that case, there's also something else just to be aware of, and that is the owner must obviously take reasonable steps to make sure that the house is safe for the occupants. Now, in that, I mean that if the first family, once they leave, the house should be to a degree cleaned and safe for the subsequent family. So that's obviously implied. And especially in these COVID times, if you do not take the reasonable steps, the owner can actually be held liable. So just be aware of that risk.
No, yes, thanks.
Yeah. And I think, you know, on Airbnbs a few months ago, you had to commit to Airbnb's cleaning protocols. Otherwise, they would not allow you to continue using the Airbnb platform. And their cleaning protocols have been compiled and approved by the former Surgeon General in the United States, and it's very thorough. So if you don't comply and you have committed to it, then you're opening a different can of worms. But I don't think this is the concern in this particular case. Okay. All right. I just want to see what other questions we had. Thank you for that, Nolene. We have people from everywhere, from Gordons Bay, from Randburg, from Kailami. And Nolene, you've asked your question. Let me just see, there was another one. Zongezo is saying, I want to find out about rental property, which my estate indicated that Airbnb is viewed as subletting, hence it's not allowed. And yes, I've seen the question around subletting a few times. And Bruno, correct me if I'm wrong, but subletting is something that is very negotiable. It is something that is normally in, if you get a standard lease template from the likes of TPN, And that normally has a clause in it that says the tenant is not allowed to sublet, but that's a negotiable clause, that if you are going to be renting premises from a landlord and you are going to be renting it out on Airbnb, it's a simple matter of disclosing to the landlord what you are going to be doing and deleting the subletting clause. In my view, it's not something that can be imposed upon you by a body corporate or a homeowners association. What is your take on that?
So I don't know if Bruce will agree with me or not, but I suppose that's the whole thing with law in gray areas. Is if we do agree, then someone's not applying their mind properly. As far as I'm concerned, unfortunately, body corporates do have quite a wide discretion when it comes to making certain rules, and then we need to apply it against what's reasonable, what's invalid, look at the reasoning for the rules and things like that. So I wouldn't go so far as to say that a body corporate can't find a good reason to say that subletting is not permissible. I, for the life of me, can't think of a good reason why subletting wouldn't be permissible, unless, again, we're trying to fight short-term letting, but there's a more direct way of doing it. So saying subletting is not allowed doesn't really make much sense to me, because, I mean, you can easily control the relationships. So to go to your point, you're absolutely right. Contracts typically say you are not allowed to sublet, because you don't want the person that you subletting to someone who you don't have control over, could destroy your property entirely. Typically, it's in the landlord's interest to avoid subletting. With Airbnb, like let strategies, it's a bit more sensical, because at the end of the day, the lessee has a strategy that he can propose, and he's actually going to better the house more than anything else. So he's going to make improvements, and he's going to really bring value to it. But you wouldn't typically just a random tenant allow him to go sublet to somebody else. So yes, it's normally a term in the contract. If it's in the contract, you need to negotiate out of it, which would probably require some level of explanation to the landlord as to why you're insisting on the term being removed.
When I think about what you've just said, and body corporates may or may not put in a rule to say you're not allowed to sublet, if I think of something outside of short-term rental, I used to own an apartment in Honeydew, and I signed a long-term lease with a tenant, a traditional lease agreement. This was a few years ago. And the tenant then, 6 or 9 months into the lease agreement, said to me that they have bought, or they want to buy a house and they want to move closer to where the kids are going to school. So can I please release them from the lease agreement? Now, this was a 5-star tenant who always paid his rental spot on time every single month. And I did not want to let go of that kind of security. And I said to him, well, you still have 3, 4, however many months it was. You still have so many months left on your lease agreement, and you need to honor the lease agreement. But what I will do is I will allow you to find a tenant, and you can sublet to that tenant, but I hold you responsible for the rental until such time as the lease ends. Now, if the body corporate had to come to me and say, you're not allowed to sublet, I'm sure I would have had a really strong argument to argue that that is an unreasonable clause.
Absolutely.
Yeah.
Absolutely.
Absolutely.
Bruce, I don't know, your thoughts?
I agree to an extent in that, yes, you can absolutely restrict subletting in the principal lease agreement. However, it seems nonsensical to prohibit subletting, as an owner can then install Airbnb. So it really does not seem to suit the purpose for which it is intended. And also, and more particularly, I'm more concerned that this might be a ploy to try and have an estate agent, for instance, be the principal lease manager, if you will, so that that cozy relationship, it can be furthered. So I'm not too certain whether or not the prohibition on subletting will actually fly, to be perfectly honest, because there is some commentary that suggests that body corporates must be very careful when they try and prohibit certain conduct, as strictly speaking, the law has to balance various interests. And the moment they start prohibiting too much, then automatically it starts becoming a question of, whoa, that's starting to become very unfair and maybe even unconstitutional.
Yeah, absolutely.
So here I have an argument which maybe you're going to laugh at, but I was listening to an American host a while back talking about this very same subject of subletting, and he said when he rents a property from a landlord and he then advertises the space on Airbnb, it is not regarded technically as subletting because he is not ceding his rights on the property to the guest. And therefore it is not subletting.
Well, now you're actually splitting hairs.
Yeah.
Strictly speaking, and now everybody's going to get very bored of this, is that you can actually cede your rights under a lease agreement as a lessee to somebody else. But that's completely different to concluding another lease agreement with somebody else so they can occupy the property. It's two very different concepts in law.
Okay.
Yeah, so maybe just the best example of this is in South Africa, we have very specific tick boxes that you need to go through in order to call it a lease agreement. If you tick those boxes, it's a lease agreement. And so typically this would be, there's an object that somebody else is making use of and enjoying for consideration, but temporarily, right? And that typically is your lease. So if you tick those boxes, it's a lease. And a sublease or it doesn't matter. It is a lease.
Still regarded
as
a lease.
boxes.
So it would be, okay.
Yeah.
Good. All right, let's, Songezo, I hope that we have answered your question and not confused you any further. So let me go to Lee's question. Lee is asking if something goes wrong with a guest damaging another person's property within the sectional title estate, can the body corporate hold you personally liable and sue you in your personal capacity?
Well, I don't mind if you would. I hope nobody minds my way in here, but the body corporate can't sue you on behalf of somebody else. Think of, if I break your pretty lamp in the corner there, your body corporate can't sue me for breaking your lamp. That's nonsensical. You could sue me. So that's first and foremost addressing that aspect. However, the owner or the person who would otherwise be entitled to sue can sue you if there's damage. For instance, let's give an example for when the body corporate can actually go after you. Is, for instance, one of your guests comes into the estate and they drive over a lamp. Then the body corporate can try and come after you as the inviter of said guest. But in all probability, and to be strictly on, and to be perfectly honest with you, it's better if they go directly after the person who actually caused the damage. That's a better nexus in our law. Bruno,
I've not read the fine print on Airbnb's insurance in this regard. And that is one of the reasons why so many people love using Airbnb as hosts to rent out their properties, is the moment that, or as long as a booking has been made on the Airbnb platform, you are covered by Airbnb's insurance, and there's what they call host protection insurance. And if a guest damages anything and they don't want to pay for it, and you try and claim it from them and they refuse to pay, then you can submit a claim to Airbnb, and then they will look at it from an insurance claim point of view and most probably settle it if it ticks all the boxes on their side. Now, if a guest damages something outside of your property, I'm not 100% sure, but I know that there is a separate insurance, not the host protection insurance, but another insurance in place should, I don't know, let's just create a really absurd example. A guest leaves the stove on and burns down your kitchen and the fire spreads to the rest of the complex. Touch wood, heaven forbid. Airbnb does have insurance for those kind of things. So you may, I hear what you're saying, Bruce, and I agree with that. But if they do want to claim from you, you might have a chance at going to Airbnb and asking them.
So I think, so to echo Bruce's thoughts, maybe we need to so separate the different types of claims that may exist. So before we look at the insurance component of it, it's always important to figure out whether there's an actual link. So it's a nexus between the parties, one, whoever suffered the damage, whoever caused the damage, right? So my feeling from this question is people wanted to ask if the body corporate has a claim. So sometimes you find a lot of this with issues that happen in the complex, any enforcement that the body corporate has, even fines, penalties, you name it, right? But damage to common property, briar places, pools, fences around, certain areas, gyms nowadays. So typically the simple answer to this is most body corporates will say that the responsibility of the people that are there on your instance carries over to you. So they want to make sure that you as the owner take responsibility for who you allow on the property. So if there is a fine to be levied or a damage to be claimed, typically the nexus arises between the body corporate and the owner of the property that allowed the damage to actually occur. And that's something that you will usually find in the rules, in the conduct rules. So that just kind of answers the way that I understood the question to be asked, is there might be a claim against the person that caused the damage, but the owner would also more than likely carry some form of liability in those instances.
I think it dovetails with what Jill is asking in the comments. She said, are we not referring to damage to common property in a sectional title where there is insurance in place? So I think there's going to be a difference between, my guest accidentally bumping the neighbor's car, in which case the claim would be between those two parties, versus my guest running into the complex gate. I think.
Yeah, absolutely. Yeah.
All
yeah,
right.
Absolutely. Yeah.
And then if we go to, Jill, I think we've covered your question at the same time. Then Munyaratsi is saying, so if a body corporate stipulate that there should be a lease agreement for all tenants, does it imply that Airbnb is not allowed? Bruno, from what you have said about the essentials that determine the tick boxes that determine whether it is a lease or it's not a lease, if somebody books with you on Airbnb, it's a lease.
Yes, and moreover, even if you take a step back away from Airbnb, remember lease agreements don't necessarily have to be in writing. So if somebody agrees to pay you consideration in exchange for use of an object on a temporary basis, that also comprises a lease. So for all intents and purposes, a body corporate saying something like that is nonsensical, because a lease can be done over the phone.
Okay, yes, right. So I don't see, there is some form of agreement between a host and Airbnb too. Yes, correct. Okay, Munyaratsi, we've answered that. Thank you. Bruno, can you have a look at your questions there and see what the next one is?
I think being mindful of time, we might need to just group some of them together. So I remember there was a very common theme. So the next question was around rules created by developer, where they expressly prohibited short-term letting. And I think this question echoes quite often across. I mean, the other ones are regarding statutory insurance. I remember there's another one regarding the commercial use. So short-term letting being commercial use and the body corporate not enjoying that. And I mean, it's, covering almost like 50% of the questions around whether body corporates are allowed to stop or prevent hosts from renting out their properties using platforms like Airbnb on a short-term basis, right? It would be arbitrary to prohibit Airbnb specifically. So again, we're moving away from this and we're referring to short-term lets. And we're saying, is it allowed that a body corporate can stop this type of short-term letting? So the bad news is that a recent court case, high court case in South Gauteng, the judge did find that it was reasonable and not unconstitutional for a body corporate to promulgate rules that prohibited certain types of leasing, and it applied certain tests to this. So the court typically looked at to give you background, basically, the host refused, and the body corporate went to court to try and apply to get an order stopping her from using the property. She then counter-applied and asked the court to consider the rule as unconstitutional, versus Section 25, the right to housing and use of property, etc., and arbitrary deprivation. So the courts looked at all these aspects. And the reality behind it was the court, and it was context-based or context-specific. The court specifically used this terminology where they look at the specific context and they consider whether it's fair, effectively, whether it's fair to prohibit someone from doing it in the greater scheme of things. So if the body corporate is able to show that a security concern arises due to short-term letting, unless we as hosts are able to counter that and say, hold on, no, wait, but that's not sufficient reason. We feel that from our perspective, there's a better approach. We can do away with that fear that you have by allowing for this, making your rationale behind the rule unreasonable. And I think that it's very important to emphasize this, because people are going to read that court case and say, body corporates can do what they need to do, and Airbnb hosts just need to kind of swallow it. And I think with a judgment like that, a lot of body corporates are going to hold this piece of paper up and show to everyone and say, look, it's allowed. And I think it's important that we take a step back and say, well, what exactly is allowed? A body corporate isn't allowed to just promulgate or proclaim any rule that they want. It still needs to comply with certain good reasoning, fairness. And if you look at CISOs, for example, the invalidity of a rule and reasonableness of a rule is something that's taken into account. If you look at our courts and our law, for instance, taken against the Constitution, whether it's constitutional, whether it deprives a person's rights of use over a property, all these things are taken into account. All the court looked at in this specific instance was, listen, there is a deprivation to a certain degree, but it's well balanced for the needs. And at the end of the day, there's people have agreed to live underneath or within the confines of these rules that the body corporate creates. So unless they can prove it's really unreasonable, the context here dictates that it's not that bad. And, as per our conversation yesterday, they actually even the court even mentioned at a stage that they'll look at the complex. What was the complex designed for? So one of the questions over here was that the developer had a mental block because he had this concept or this idea that everything's going to be silent and there's no outsiders. So the reality is, if the majority of people within a complex carry this view and they want to create a ecosystem within this complex that has very few outsiders, that's very quiet, maybe something sort of a retirement village, to a certain degree, it's fair for the majority to say, well, this is what we want, and this is how we're going to apply it. And if a lot of the people agree, it's not arbitrary. It's not necessarily unfair, unless the person that's getting impacted can show that there's a better way of dealing with it. So unfortunately, the case law does indicate that body corporates can make these changes. My advice, though, is each case needs to be taken on its own merits. So we need to look at it. We need to come up with strategies that we can apply across the board to all these arguments that give reason to these change of rules. And if we can start applying this and submit proposals going, I get your security issue, but here's a proposal that does away with it. Here's stats on what happens with long-term traditional leases, and here's stats what happens with Airbnb. Maybe there needs to be an application around this sort of thing. And I feel with that, we're strengthening our arguments and making it more susceptible to reason, where courts may actually find in our favor.
Right, that makes sense to me. I think 2 more questions, Bruno, then I think we're going to have to wrap up. Tanya, I'm going to give you a chance. You put up your hand, and then I'm going to go to Jill's question in the chat box.
Okay, so it's Gert again in Tanya's stead. So the complex in which we're in have a rule which basically says, you know, occupants per bedroom cannot exceed 2 as imposed by the City of Cape Town in its occupancy classification and design population. So it's a 2-bedroom apartment, what 81 squares, and you know, typically I think you'll get, you know, a couple with 3 kids, which it would be ideal for. I mean, does the city really tell us how many people can be in a bedroom?
Sure.
Well,
yeah, go for it, Bruce.
The thing is, these are sort of the considerations that are taken into account when zoning is considered. And unfortunately, local authorities do have the power to dictate what certain zoned properties, what their occupancy can be, right? For instance, think of hostels. They will definitely want to regulate that and ensure that it does not become so dense it's actually a health hazard, as is the case with the hijacked buildings in Joburg CBD. Everybody can agree that that is a health hazard and it's dangerous for all concerned. So the local authority can impose such restrictions. Again, they must be reasonable. They must also be fair, considering everybody's respective rights. When you mention children, now this is where things get a little bit more difficult. And again, it gets even a lot more grayer, but typically they can dictate the occupancy. And I've seen this actually done in Ekurhuleni municipality, where depending on your residential zoning, they can specifically say that you are only allowed this number of people on that property at any given time. It's for health and safety. So unfortunately, it is permissible. Gert, I hope that answers your question.
All right, I think we've lost Gert there for a second. And Jill is saying, if one incorporates the body corporate house rules into the Airbnb rules, then would this constitute a reasonable counter argument? Now, I would say absolutely yes, because on Airbnb, when you book as a guest, then before you can confirm your booking, you have to agree to abide by the host's house rules. And the host can add additional rules over and above what Airbnb provides. So you can go and put in an additional rule to say that the guest will abide by the complex's corporate, what is the word I'm looking for? House rules. Conduct rules.
Mm.
Thank you, Bruce. And I have that generally across the board in all my listings, that they have to agree to abide by that. One last one. Miles is saying, is Airbnb against municipal bylaws in a complex?
That's a toughie.
Yeah. Is Airbnb against municipal bylaws in a complex? Sorry, maybe just to break down this question, if Miles is still there. So municipal bylaws and obviously complex rules.
Where is Miles? Let me unmute Miles and then he can elaborate on his question.
Hi.
Hi.
So what happened with me is that I mean, I keep receiving fines from the body corporate each and every week, every time there's a guest, and one of their lists, one of their concerns are that it's against municipal bylaws, the hosting of guests. So I'm trying to understand
what area are you in?
I think it's in Benoni. So the letter says the owner is in violation of municipal bylaws. The building has been zoned for residential and not commercial purposes.
That's very interesting. So, so the municipality. Sorry, Bruce, do you want to go for it?
Yeah, but my biggest concern is that it sounds like the body corporate is trying to enforce municipal bylaws. Typically they cannot do that. If it's one of the body corporate's rules or the complex's rules, then that's a different story. In such situations, the municipality would actually have to come and impose the fine, and also the body corporate would have to have a rule that permits them to levy a fine, and that fine must be in the rules as well. So that's a very interesting question, and I hate to give the lawyer's answer, but it also depends on what is in the rules. But
so the way that I read, sorry, Bruno, the way that I read that, because Miles sent that as one of his questions, and he sent a screenshot of the letter that he received. So the way that I read that letter is that the body corporate is trying to say that your short-term rental, Airbnb, is a commercial activity and your property has not been zoned for commercial purposes.
That's correct.
And that brings my argument that I've had discussions with you or with Bruce about previously. You know, if my neighbor rents out his whole house on a month-to-month basis, because that's his property investment, and I rent out my house for 2 weeks at a time because that's my property investment, what makes the one commercial and the other one not?
Absolutely. No, and that's spot on. And that's one of the problems. If you look at Consumer Protection Act, then for all intents and purposes, a traditional landlord is also commercial because they're considered to be conducting business. You still need to comply with Section 14 of the CPA. So, you know, if the municipality allows leasing, the municipality allows leasing. And I don't know of any bylaws that define leasing as being more than a month. So municipal bylaws use the word lease, where some confusion might arise. And this is a constant debate I'm having with people, is when you look at guest houses versus, you know, like house sharing or house letting, because guest houses are expected to be tourism compliant. They're expected to be, you know, fall within certain zoning parameters, running businesses like guest houses, and obviously more denser businesses like your hotels and things like that. But this has always been an issue. That's why Cape Town jumped ahead of this and allowed for the 31-day period as your typical letting, because I think they did notice that there could be a bit of confusion as to how you take a guest house and the zoning rules pertaining to guest houses and how you apply that to Airbnbs, which is just somebody's house that they're letting on a short-term basis. And this goes back to the conversation that we had about then government coming in and saying, well, we need to regulate it because it is a house, yes, we agree, but they are functioning as guest houses and bed and breakfasts on the other hand. So we are in a bit of a conundrum here because and the way that Airbnb hosts supply the platform is different. So some guys literally treat it as a guest house. I know guest houses that use Airbnb to find occupiers. So I mean, the reality is it's a platform that works as a guest house platform. It's you know, there's bed and breakfast that use it, or there's a guy with a room and he says, listen, somebody come in, you want to stay in the room, cool, go for it. And I think that's where the government intervention is coming from, where they don't want it to seem unfair to your tourism service providers that, you know, people are just jumping in here and taking part of the industry. And I think this, you know, it's that kind of balancing act that we spoke about at length, whether they're doing it the right way. Cape Town tried to deal with it by allowing the 31-day period. As far as municipal rules are concerned, my argument is they haven't done anything yet to define Airbnb or short-term rentals any different from your traditional rentals. So they shouldn't be able to stop you if you can prove that you're not really running a guest house. You're actually just renting out a room, then you could fight them on that, I feel.
All right, I think we've had a really productive session, and those are all the questions that we have time for tonight. And what I will do is I'm going to post the recording of this on YouTube, and I will make sure that everybody who registered for this workshop gets the link to that. And I will also share Bruno's social media and website and all his links where you can contact either him or Bruce. And Bruno, I think the biggest takeaway for me from tonight's discussion, thank you very much for the discussions in all directions. And the biggest takeaway for me from tonight is that there isn't really any legislation in our country that governs short-term rentals. I think the way that we do business has evolved so quickly over the last 10 years that legislation simply hasn't kept up with it. And slowly but surely, we will eventually get a better indication. And I'm all in favor of getting better guidance and better legislation so that we know what we can and what we can't do. But those are all things that are going to take time. And in the meantime, it's very debatable, and every case needs to be considered on its own merits. And the more responsible a host you can be, the better this whole thing is going to play out in your favor. And that, in a nutshell, is what I took away from tonight's session. I don't know if there are any closing comments from you and Bruce.
Bruce, do you want to go? I'll give you the closing comments.
Thank you, Bruno. I feel so honored. Well, I share your sentiment, and in a nutshell, the more you can interact with the trustees and the body corporates on good terms and show that you're willing to work with them and actually help them in some cases so that they can help you, the less likely they are to take draconian action against you to outright ban it. And so this again comes to being having a more of a mediation mindset rather than an argumentative mindset. And I'm also looking forward to guidance from the courts and also from the legislature as to how to deal with these so that everybody's afforded their pound of flesh, so to speak. And on the last note, I'd like to say thank you for having me. It's been fun. Looking forward to the next one.
Thanks so much, Karen. I really do appreciate it. I had a lot of fun.
Excellent. We had a very good discussion, and guys, you can post more comments on the YouTube channel that I'm going to send you if you have anything, or you can contact Bruce and Bruno directly if you want to engage with them further on the subject. So have a wonderful evening further. I'll see those of you that I have workshops with in the coming weeks. I'll see you on the other side, and have a lovely evening. Cheerio for now.
Yes, thanks everyone.
Bye.
Bye.